Hey, everybody. Great to be with you today. Chuck Cook, Greg Siskin, Zach New, and Jesse Bless in his car, so he's not showing us his fancy Corolla. Um, Obviously, a lot to talk about today. A couple of things we want to do first, though. We want to go over the non-Georgia case first because there might be some folks here that want to know what's going on with the rest of the cases. I think we'll start with the 75 country case. Where are we with that, guys?
Yeah, we gave the judge a proposed schedule to go right to the final judgment. Briefs are done, but we don't have the schedule yet from the judge. So once the judge enters that schedule, we'll comply. It's a pretty tight schedule. Kind of skips most of the middle ground. So we're trying to get a judgment. You know, can't really time it with the judge, but the summer.
Yeah,
Um, so, yep, a lot of work's been done there. We reached an agreement on the schedule with the government and should hear soon.
great. Thank you, Jesse. The F1 visa revocation update case is fully briefed on a motion to dismiss with the judge. So we're waiting on the judge to make a decision with that for the visa revocation. The $100,000 fee case is still pending with the judge in California. Don't really have any more update on that today. The DV 2026 lottery case. Jess, you want to give us an update on that? I think that's really interesting right now.
Yeah. I mean, I had a chance to look at the new bulletin today. I'm putting the selection.
All right,
But
Jess,
in our
you're in a
case in particular, we filed our last brief. What's that?
you were breaking up. You might want to start over again. Or not. Let's just. So we've got our PI motion for summary judgment is done. The government's response is due. I can't remember if it's this Friday or the next Friday. It might be this Friday, but it might be next Friday, so I can't remember. But this is going to be fully briefed by early June, and
This Friday.
we will have hopefully the government's brief to share. Jess, is that brief? Is that brief due this Friday or next Friday?
This Friday.
Next Friday. Next Friday. Okay.
This Friday.
This
and then-
Friday.
This one.
This Friday. Oh, great. And then I'll reply brief you after that. So we expect to have a quick decision on that. I will tell you that we are doing a second DV 2026 suit, and that information should be up on IMMPact sometime in the next short while. Is that right, Zach? I think that's right. That's right.
Sounds about right. It's a short
Yeah.
while.
All right. And let's now talk about the 39 country case in Colorado first, because it's the second case. That PI is filed, I know, Zach. And do we have a schedule on that from the court yet or not?
Yeah, so I had a status conference. I think we emailed plaintiffs about this, but I had a status conference pretty last minute. I mean, the judge was assigned and then said 2 hours later, hey, everybody get on a call with me. The government's response was due today or yesterday, actually, but they wanted to consolidate it with briefing on the merits. So that meant that they got a little bit of an extension there. The judge was very insistent that he didn't want the very quick hearing that he set for June 3rd to be disturbed by that. So that just means that we're going to have a very quick briefing. Their response is due the 19th, and then ours is due the 29th, and then we have the hearing on the 3rd.
Terrific. Okay, and I know we're doing another 39 country ban case, which we'll put up shortly. Now, let's talk about the Georgia case. This came in right before I went live today on my live at 1 o'clock at my firm. And I know some folks were on that. We talked about it a little bit. But let's go over this case. We've received, obviously, lots of emails from people. Remember, you have to email the website. You don't, not us individually. This way, they're all consolidated in one place and much easier to answer. The decision itself is disappointing in that the judge did not grant a PI for everybody, but there was upside to this decision. Zach, you want to talk about that?
Yeah, so I also was literally walking out the door reading it on my phone, then had meetings outside of the office all day, so really just got into it about an hour ago. But good news is that, I mean, although he said PI is denied, he said if it's not lifted in 60 days, we're going to be back here, and I'm going to.
Let's talk about that for a second. This was a really weird decision, in that the judge didn't say, you know what, you've got no case here, case is over. In fact, he said, I have jurisdiction. Remember, the government wanted him to get rid of the case. He says, I have jurisdiction. I can definitely hear this case. Mm-hmm. That's a big win, one. Two, the next win was he didn't say, yeah, you have no merit to any of what you're saying. He didn't say that. In fact, when he said, he literally quoted, he kept saying the plaintiff said this and defendants had no response. Plaintiff said this and defendant's argument has no merit. But basically he then said, you know, I'm not so sure the government's reasoning wasn't okay. It was a really strange decision in that regard, because then he said at the end two things. One, anybody with a 765, if you submit another motion with them and their declarations, he'll grant it. So all of our plaintiffs that have pending 765s, if they can do a declaration, and we'll be sending an email out to everybody so that they can do this to the website about the hardship they're suffering or will suffer without this, it's clear the judge is going to grant that. Now, why would he grant that if he's not granting the PI? So basically, he's granting a partial PI. Okay, one. Two, he then said, you know, government, maybe it's not unreasonable now, but in 60 days, probably will be. So basically, rather than issuing a PI,
he put him on notice. Yeah, he put him on notice that they basically that you got 60 days to wrap it up.
So that is really interesting. Now, on top of that, literally right before we got on this call, Jesse and I received an email from the government lawyer in the case. Jess, are you there? Can you hear us? Maybe not. He's there. I just don't know. He's probably on mute or something.
No.
So about 4 or 5 days ago, maybe it was even Monday, or maybe it's early last, maybe it was Friday. One of our plaintiffs had actually been approved for his EAD last September, but he had never gotten the card. The card had never been issued. Typical government. So Jesse wrote to the government lawyer and said, hey, this is approved. Would you issue the card? And today, the government lawyer said, we issue the card. This is, hours after the decision. So we have something to work with here with the government lawyer in going back to them and saying, look, the judge gave you a 60-day deadline on these cases. I think we all agree this is an unusual order. Let's say we work together to get our plaintiffs' cases adjudicated. So we'll be reaching out tomorrow to talk to them about that for our plaintiffs in this case. So, Greg, what do you want to add to that? You have anything to add to that from your view?
No, I mean, obviously, we would have liked to have gotten the preliminary injunction right off the bat, but I feel like this judge was trying to give a split decision essentially, and give something to both sides. So, it's I'm not going to try and sugarcoat it and say it's a win. It's not a win, but it's also not a loss. It's basically we're still in the game in this case, and I think we'll probably within 60 days probably be done.
Yeah, and so what's interesting about this is a preliminary injunction. This is not a motion for summary judgment. It's not the end of the case. And PIs are notoriously hard to win. They just are. Now, one thing we did strategically in this case, I think we did this on purpose, is we went after everything on every type of case, just saying, look, these are just what they did here is wrong. That's a little bit different than a lot of the other cases who looked at EADs or looked at certain aspects of certain cases. So I know people are attacking us because of venue, because of how we did the case. Look, this is the strategy that we chose. We told you what the strategy was. We still think it's a good strategy. And ultimately, the goal is to get every one of our plaintiffs' cases adjudicated. And that's what we intend to keep doing. Zach, what would you like to add here before we go to some questions here?
I think that one of the big things is this is preliminary thoughts that we're having, 5 hours after we got the order. One of the things is I don't think that we have a terrific answer about how we're going to solve every single problem right now. I think that there's still discussions to be had amongst us, and then we can really have a coalesced plan for everybody about how each of these situations that folks are in can be more holistically addressed, I suppose. So that's, I guess, my initial thoughts. And I've got a lot of emails about what are we doing about X, Y, Z. Part of it is I don't want to say we're going to do this and then we come to do a different thing. You know, I do want us to have time to think through the best strategy on how to respond to this.
Jess, did you have anything to add before we go to questions here about the Georgia decision? I know I saw.
I'm so sorry. I got cut off. So my read of the judge, my read of the judge, and then just, you know, kind of assessing the timing of his decision combined with how things went at the argument was, he really wants to allow the government to increase its vetting and security in the way it wants, but it cannot be indefinite. And for him, that's 60 days from today. So I know this is disappointing and everybody should have received the decision by now. I think that's the whole point. You know, we're accountable. I feel awful that, you know, we didn't score for everybody, but I really think the judge took a kind of bigger approach than the other cases. It's not going to help anyone today, but I think he really did, like what Greg alluded to. Like he said, listen, you can change your standards, get on top of it, do it, but you know, it can't be indefinite. And for anyone who doesn't have an EAD and has one pending, that really is irreparable, and I need to address that. So bring that to me. I think we should go back to the government attorney and see if he'll resolve the pending EADs for everyone, and maybe you know, win by negotiation, and then see what happens in 60 days. You know, but it's not going to bring anybody relief. I can't see the comments. I'm sure they're not great. The reality is, it's, you know, you can blame me. Blame me if you're going to blame anyone. Don't blame anybody else. You know, social media is a good place to blame me because I'm not on it. But I really do think that you need to take one step back and a deep breath, because the fight hasn't even started yet. That's my take.
Thank you, Jess. I agree wholeheartedly. Let's look at some of the questions here. Regarding will the new motion be another PI that requires hearing takes as long as the previous one? I think Jesse just addressed that, and I don't think it would. Clearly, the government's on notice that the judge wants these EADs granted. So we'll first take these. Hopefully, if you can get them this, you can get this stuff. I know the website's getting peaked right now through Jana, and we can hopefully get this early next week and get to the government lawyer. For all of you, for all the plaintiffs that have pending 765s and a reason why you need it now, like you may be expiring, you're losing a job, you're having a new job that starts next week, whatever it is, we want to put that in the detail. So no, it's not going to be a regular PI that takes forever. It's not going to happen that way.
One of the other things is, I think based off of the reasoning in the judge's order, when I was talking to one of the plaintiffs about this, I think that the reasoning can be extended to some other statuses as well that have work authorization, like, you know, pretty much tied to them. If we're saying, you know, it doesn't make sense for 765s. Yeah, exactly. If 765s who are already admitted, 4 people who are already admitted should be granted, then why not extensions on H-1Bs or J-1s?
What I took from the judge was that he wasn't hyper concerned about adjustments in Nat's cases, because he actually talked about those specifically. But he didn't really talk about visas, that anybody needed a visa extended, needed the work permit in place for that. So I agree with you, Zach, that I think we can expand.
I agree with that too. Anybody who's about to lose work authorization, I would put in the same category as the 765. At least that's how we're going to explain it to the judge.
Yeah, in fact, I think we need to ask folks for that. If you've got an H or an O, whatever it is that's expired and you're losing your 240 days, I think we ask for that as well.
Well, I think
You know
there's
who,
one other.
man?
There's one other.
Yeah. Yes.
Hey, can you hear me?
Yeah.
Yeah. So there's one other. There's two other categories that I think are important, and I know, Greg, you touched on this the other day. I have confirmed that the medical professionals exception is real, and people who are just matched with residency programs, they're going to get their EADs. I don't know when, but they have like a June 1st cutoff. So, but I think we can make it and push on that a little bit broader to include anybody in the medical professional field. And then I think anyone waiting on like OPT or STEM OPT, I know that it also includes an EAD, but I think, those and the 539s, absolutely. So people who are going to lose status or lose work or both, would all fall into that one bucket, which would be a lot of our plaintiffs.
A lot of our plaintiffs to get relief on this, at least temporarily in the process. What is your plan for the negative factor?
I mean, it's just continuing briefing on that. It seems like he didn't really even give that much consideration, which was really strange in the PI decision.
Well, I think he did notice that the government didn't brief it at all.
Yeah, that was the strange part. Like he said that we didn't.
His talking about it was odd, and he didn't address our legal arguments that were directly on point, saying it's against the law. It's literally, there's a statute on this, Judge. He didn't even mention that. So we'll go back to that. We'll get back to that with Judge.
That one's the PI is not over for that. The PI is not like the end point for any of these, but it's especially not for that, where we've got basically no reasoning. If that was the end that we got there, it would have been we would do a lot more. So there's a lot in the works still, I guess, for that. It's kind of behind the scenes thing.
So what harm would the harms by H-1B? Again, we just talked about that. If you've got a visa that's expiring, I think that falls in the same category as a 765. And I think we can argue that effectively to the government lawyer and to the judge. Well, the TRO, it's not really a TRO. We're not filing a TRO. The judge just invited us to go back. And that's what we'll do with a straight motion on this and working with the government. I mean, I think the government's more than happy to work with us on some of these issues. Let's see. The judge is completely aligned with the government on the negative factor. Well, that's impossible because the government didn't brief the issue. So we already talked about what we're going to do on that. Think gaming, the next update in the DD lawsuit once the government files their reply. The government's response is due Friday. Our reply is due a week later. And it'll be fully briefed by the end of the month.
No, Chuck, we're done. We're done with briefing.
Oh, that's right. We're done with the DD lawsuit. That's right. Awesome. Now
we're done with briefing. So the next thing would be a hearing or a decision.
Great. All right. Clear neglect in district selection time. Oh, so we have U.S. Travel, a experienced immigration lawyer. Thank you very much for your comments. Is it possible to withdraw from the case? Some people have asked us about this. Withdraw the case and submit it to another court. Jess, you want to talk about this a little bit?
Yeah. So, I mean, it's certainly something to discuss. It's, you can do that all the time. I don't know if the idea is to get a quicker, favorable judgment, if that's the best solution. It's something that but I think that, shooting from the hip 2 hours after you get a decision is probably not the best time to start making decisions. You could, we've done it in some other instances, but I mean, again, there's downside. There's timing. If you file a complaint, you got to serve it. I mean, yes, you can go get a TRO, but it's definitely an idea. It's on the table. We have to balance that with perhaps getting EADs and work authorization for people quickly. And, that's an inexact science, but I mean, we have to think about it and we will.
Exactly. Let's see. I'm an N400 plaintiff. Since the PI was denied, was judge the next steps. Well, again, he didn't dismiss the case. This case is still pending. And at a certain point, if there's no other discovery to get, we can go to summary judgment on this issue. So at this point, I think leaving the case would be silly, especially if you want your EAD approved. And there's no guarantee wherever you go next that you don't get a worse decision. I mean, there's not. So at this point, I think we continue fighting this case. Let's see. For the
most of the cases don't have decisions yet.
No,
You know, there's some comments out there. It's like, oh, you know, it's like, how did all these, you know, you guys are the first one to lose. Well, there would have been 4 or 5. I mean, there's only a handful of decisions so far in these cases. So there's like 30 of them.
The 39 country ban case describes plaintiffs as admitted into the U.S. I'm a Canadian dual national amount in the U.S. Still valid for me to be in the case. Zach, I'll leave that one up to you.
Do you have a benefit that's pending? You could still be in the case.
Right.
This is one of the interesting issues with the pause is that although you are not subject to, and sorry, I'm answering emails as I'm on talking to you guys. So although you're not subject to the entry ban, the pause still impacts you. It's one of those weird things that it shouldn't apply to you. Like the reasoning for the pause in the first place is those country bans, but you're exempt from that. So why would you be subject to it? But anyways, you are. So if you have a benefit that is in the U.S. pending, you certainly could still be on the case.
You know, this is a good question. To what extent does the Georgia case affect the Colorado case? Now, Zach, you're doing the Colorado case.
I think
you know what's interesting about the Georgia case first? The judge cited every other case positively, right? He didn't say these guys were wrong. He didn't. In fact, that's probably what led him to the 765 thing. He just wasn't convinced to throw all the policies out at this point. So I don't see an effect in Colorado. Zach, what do you think?
I don't either. This is one data point that's pretty minor, and also even if the judge in Colorado was to look at it, he would say, he gave him 60 days to make a decision. So even he thought this was getting too far. So I don't see it impacting the Colorado case.
I agree. Does the physician exemption, Jesse, for the ban apply to physicians outside the United States? I don't think it does.
No. And the only guidance I have right now is that, you know, people who have some severe like urgency, rural physicians, residency matches, J1s, perhaps, you know, I have been able to resolve those. You know, the other thing is,
Kind of lost you, Jess.
everybody on this call, by the way, or at least most of us, have one either in.
Jess, we're losing you. You must be in a bad location. We'll come back to you for that. Here's what the problem is. They're too convoluted. Are you planning to separate them? No, we're not planning to separate them because the issue is common to everybody. The issue are the 3 memos. That's the issue. They all carry the same weight. They all carry the same harm to people, just in different applications. And we remain convinced that we can win this case, which is why we're moving forward with it. All right, let's see. If the judge lifts the 45 hold but leaves a negative factor in place, couldn't he just deny using the country-specific depressions? See, I think that the negative factor stuff, he does not understand. So we'll get to go back to him in another argument and explain that even more thoroughly than we did in the briefings that we did. Zach, what do you have to say on that?
Yeah, definitely agree. I mean, the negative factors, he gave it, what, a page and a half, if that, when the government didn't even respond to the arguments. So, you know, basically saying, you know, we didn't give him the information he needed when we never had the opportunity to. Was, I don't know, I was a little peeved by that, but we'll be coming back to the negative factors thing. They couldn't just deny, like they couldn't just lift the pause and then deny everybody. That's abuse of discretion. It would be
no, the judge won't be happy about that either.
Yeah.
In Nezma Islami, we pushed the judge to issue an injunction forcing us to adjudicate something like 60 days. I don't think he's going to give them 60 days to adjudicate these EADs. No, I think it'll probably be 30 days at the most. So mean, there's not that many. I mean, in the grand scheme of things, there's not that many cases that they do them in a day or so. Jesse's back again. Okay. Yes. Zach, do you want to explain? People sent an email to the contact page and no answer yet. Can you explain that?
So the contact page emails currently go to me, and I have about 300 of them to go through right now. So I will be getting to you. I just have a lot of them right now. I apologize.
Yeah. And so our emails are not answered by AI. They're answered by a human being. So you just have to be patient. And 2 hours is nothing.
That's what I'm doing right now. So as you guys see me not looking at comments and questions, it's because I'm answering these. So I apologize if it's taking a while. I am trying to get through them as fast as I can. I'll get through all of them before I leave the office today.
Here's an entertaining thought. Take the case to California, a nice liberal state. I just asked Pierce, Greg, where's our $100,000 H-1B fee case? Where's that at? It's been pending 3 months. California.
San Francisco. We're waiting since that argument was basically the same week.
Yeah, same week. So what's interesting about California is the Ninth Circuit used to be the most liberal circuit. It's not anymore. Trump has put a lot of judges on the court out there, and California is not the automatic place you want to be. Let's see. A lot of these are the same questions, so I'm just going to skipping over them.
I mean, the one thing that people need to understand is there's no free rides out there, because, you know, there are complications in every single case right now because we're all fighting the same battle, and judges really are confused about how to get their arms around something that's a moving target for every benefit. There are issues in the Massachusetts stuff. There were some issues with the California case, a couple of them. We're all trending in the right direction. Today is definitely a setback, but judges are really struggling with this because we really can't find the truth about what's going on, and that's the problem. I'm not so sure the government attorneys know. So, you know, I think we're all kind of learning as we go forward. You know, we got an EAD approved today. I know that doesn't mean a whole lot unless you're that person who received it, but I think there's an opening here to get some benefits quickly if the government wants to do it with us and listen to the judge. So I can only imagine how awesome those comments are, but that's really, you know, we're not the enemy. You know, we're trying to help.
Absolutely. And as we said from the beginning, we think this case is winnable. We think this law is, what they're doing is illegal. But unfortunately, we're not judges. All we can do is make the arguments here with the information that we have. So Mojanixa doesn't think there's any upside, then you don't have to get an EAD. But if you want an EAD, please send your information so we can get that for you. Let's see. Let's see. Are you planning to have a meeting for the Georgia case plaintiffs? That's a good question. Zach?
I just sent an email saying let's schedule this. So yes, yes we are. That way we can talk a little bit more in detail and about, I guess, some of the I don't know, in the weeds stuff a little bit more. And also gives us a second to digest this, so we can have a little bit more concrete of a plan for you on some of these more minutia type points.
All right, so we have lots of upset people here, and that's fine. You're welcome to be upset. We have to keep fighting the case, however, and the case is not lost. The case is still ongoing. Let's see.
Why don't we talk about Georgia? Why Georgia? One of the big things is joinder, and that's why we picked Georgia, one of the biggest reasons initially. So if you guys recall from the briefing here, the government filed a motion to dismiss the case, and part of the reason they did that is based off of joinder of the plaintiffs, saying that everybody should have their cases severed, or else the couple of people who live in Georgia should have their case moved forward and everybody else's case should be dismissed. Georgia has very good case law on this, and I mean, our response to that was very strong. I know everybody's mad about briefing right now, but this is a very strong issue for us, where it is a bit of a weakness in these types of cases in general. So by picking Georgia, we have good case law that allows us to keep our plaintiffs together and avoid this kind of implosion of the case as a whole. So I know it's not where everybody immediately thinks an immigration case should be filed and where big cases should be heard, but and we had one last year here for 150, 200 students that had the same kind of thing moving forward. It's not a bad district, even though it has a lot of kind of Republican-leaning political.
Personally, I had great experiences in this district, including with this judge. This is a good question. Why was the entry ban mentioned in the PI? I mean, the judge talked about the entry ban, which I found interesting because we talked about that in the context of it not being relevant inside the United States. And he said that the entry bans were the basis of the government's orders, but they can't be because they don't apply inside the United States. That's interesting enough. I don't recall the government making that argument. So I don't really know where that argument came from, except from the judge's own mind.
It's also a pretty absurd argument because plaintiffs who are in the United States are exempt, or dual nationals, who are a lot of our plaintiffs, are exempt from the travel ban, and he didn't take that into consideration at all. So anyways, there's a lot of things that we could be just disagreeing with a judge on for the PI. Don't need to just be ranting here.
All right.
When they came up with the memos, they cited back to the president's executive order on the first day he was sworn in. So that's where they're getting it. Like that this is all part, like if you go back to the judge's reasoning, this is all part of tightening the security checks, which began on day one. And so this has been an ongoing process. I think that's what he's trying to suggest. And he just says it has to end soon.
Okay, somebody asked this. Do you guarantee the judge will issue? Of course not. We never guarantee a result. We can't. We've never talked about that. There's inherent risk in every piece of litigation. But the judge has said on the 765s that he's clearly going to grant those and order the government to issue those. So 60 days, this is a long fight. Remember, nobody else has a final order from the judge. Nobody. So even though some have won PIs, and awesome to them, we're going to get at least a partial PI for our 765s, which is equal to at least several other lawsuits. And we'll keep fighting, of course, for the judge to come to a different conclusion about these three policies. Okay. It seems really interesting, Zach and Greg and Jesse. People seem to think that because you file in a democratic state that you automatically win. Jesse, you file lots of lawsuits in democratic states. Do you win all those cases?
Yeah, but I mean, I think it looks that way on paper right now, because people need to make the
Jess, we've lost you. You must be in a really bad location. I'm really sorry to say. Let's see here.
Very simple.
So somebody asked this question: can you withdraw from the lawsuit?
And they're upset.
Yeah. So Zach, can you withdraw from this lawsuit?
And withdraw from the lawsuit. It requires us to have.
Okay. I mean, I think
Jess, you're breaking up. We're losing every other word, my friend.
Right to be upset. I'm upset. They have a right to withdraw, and they have a right to stay. I mean, I don't think the judge issued this decision in the news. You're what's quick and it's just not. I don't know how that happened, but I also don't think that you should throw away or criticize the entire case because you received an unfavorable order. I mean, for God's sakes, I would have been fired my second day on the job. Litigation is not easy. So, like I said, you can choose what you want to do and how you want to do it. But sitting here and playing like, hey, you should have done better on that test is an awful way to parent, and it's an awful way to be a client.
So, Zach, you want to address that too?
By withdrawing the lawsuit? Yeah. So for that, we would need your pretty explicit confirmation you want to be withdrawn from the lawsuit. We would need to have approval from the government attorney because we've gotten kind of farther into the case. It's not just a notice that you file at this point. But it's certainly possible to do. You just, I mean, if you really want to, you let us know and we can get you withdrawn.
Well, Zach, hold on. They have not filed an answer or a motion for summary judgment, correct?
Correct.
That's correct.
Just
so just notice actually.
Notice, because the motion to dismiss doesn't require a stipulated notice of all. Yeah, so they can.
So there we go. Just if you want it to be withdrawn, we just file a notice of people who want to be withdrawn, and that'll be.
We can just do a notice, and we can do it with it.
Jess, we just simply can't.
We can just say, hey, notice of withdrawal. We just have to be careful.
Wish we could hear Jesse.
But bottom line there, we could file a notice of a withdrawal for the plaintiff, notice of a voluntary withdrawal for any plaintiff who wants to withdraw.
Now, I don't think you should withdraw, especially 5 hours after a judge issues an order when we have a plan to move forward. It's obviously your call, but if you'd be starting over somewhere else, you would be that much further behind the 8 ball, especially if you've got an EAD or if somebody asks about 539s. Obviously, the 539 with status expiring, we're going to ask the judge to rule on that issue as well, because it has the same urgency as the 765. And so we'll need your specific information about, there's very focused on the immediate irreparable harm that you will suffer if it's not adjudicated right away. So the judge, that's what he's looking for in your specific case. Let's see. A lot of these are the same question over and over again. Okay. We did talk about the negative factor earlier on in this broadcast. You go back and take a look at that.
Speaking of the negative factor, though, I haven't seen or heard many, if any, denials on that ground. A lot of noise, a lot of RFEs, not a lot of denials from what I've seen. I mean, obviously, if you're subject to the pause, there shouldn't be, but even on the cases where PIs have been granted or cases that I've settled where the negative factor should apply, I have not had anything but an approval.
I have as well. All of mine have been approved as well. Now, this young man is disappointed. We're disappointed as well at this point with the judge's decision. At this point, But if you have a STEM OPT, you need to write up that declaration for us because we're going to ask the judge to get that approved. That's an EAD or 765. So we're going to ask him to do that as well, which makes it a win for you if we get that. Okay. Let's see. Some folks think we don't have empathy, but that's absolutely not true. We know exactly what this means, and we're trying to get to the point where we can still win the case for you. All right, let's see.
Well, I mean, I have empathy. I mean, I feel like dog shit. I mean, I feel like I lost, but I can't be in your shoes because you guys are the ones really are in pain. I mean, my job is to take my feelings and leave it aside. I mean, I was also the guy who was negative before we even lost. So, I mean, I must be a real prick. So, you know, I think the feelings, you don't want a lawyer with feelings. You want a lawyer with skill. That's what we're trying to show. You know, you can have feelings, and we have feelings for you, but it's not helpful if we're all crying.
Our job is to move forward as fast and as positively as we can. Somebody asked, "You think there's going to be an exception for other professionals?" I don't think so. Greg, do you think the government's going to have any exceptions for other professionals, like they have for doctors?
No, and the doctors, we're not even clear how extensive that is at this point. So I'm not expecting anything.
I think
the doctors they were forced into, right?
I think there are going to be some exceptions for the non-immigrant visa categories where the petitioner is a U.S. employer. I settled a case this week for a giant corporation. It was an L, and I know, Chuck, you were on that email chain, and I couldn't really say much, but I think if you have a U.S. employer on an L extension, they'll look at doing something with that because the person has been recently vetted. He's an executive manager or specialized knowledge. I think the same could be true for H's, except they just hate that program so much that maybe not yet. For L's though, I think that's possible. For O's, maybe.
Okay, somebody said, "Is it true what the media is saying about the hold on Venezuela's hate being lifted or eased?" I have not heard that. Jack, no. Greg, I haven't heard that at all. Especially for Haitians. I don't know why they'd raise it for Haitians. They hate Haitians. Can I get relief on this PI for apply for a STEM OPT later this month? That's a good question. I mean, if you have a pending 765, we're definitely going to give that to the government lawyer. If you don't have a pending 65, but you're going to add it later, we'll go back to them later if the case is still going on and we haven't resolved it by then.
Yeah, I think people need to ask themselves this question, and we can obviously help them with it. If I don't get this benefit, this horrible thing is going to happen. Loss of work, loss of status, something like that. You know, you have a deadline coming up, loss of residency program. Like, there has to be a specific identifiable thing. Loss of status, loss of job are obviously the two best that we can think of at the moment, but start asking yourself that question.
Chuck, somebody was asking about whether we could provide some information on the 765 declaration and how to maybe structure that. And I'm sure that's something that we can help with.
Yeah, we can get John to send that out to everybody as well. We'll work on that when we get done here.
Yeah.
Postdoc.
Just one thing on the declarations, though. I think we want to be careful. So if we send you a template, don't take it, fill in your name, and sign it and send it back. Spend time making the declaration your own declaration, your words, your signature. The more specific you are about your case, the better, okay? Because the judge doesn't want to see 50 declarations that only have names changed. It has to be specific to you, and only you can do it. And if you don't speak English, do it in your native language, and we can, you can get it translated, or we can help you with that. Okay? That's super duper important, because I think judges are going to start getting critical of that.
Jesse kind of talked about this a little bit earlier. Professionals working in medicine, like cardiac, are those in healthcare groups? I think you make the argument that they are. I mean, absolutely, definitely make that argument. Okay. So this is a good question. What are the plaintiff's risks of retaliation, and emphasizing a factor? Again, this is described in our FAQ. We have never seen retaliation for any lawsuit, win or lose, by the government. I just haven't. I'm Zach, Jesse, I've never seen that.
I mean, I just think, like, if we're going to go to the nearest thing, I mean, today, after the decision came out, the government attorney told us that one of our plaintiffs was going to get a ZAD card. So, I mean, if there was ever a reason to spike the football and tell us that, hey, go pound sand, they would have done it. But, like, they're actually giving our client what he deserved, and that's the opposite of retaliation. It's actually empathy.
And Jesse, I know you've talked before about it, that the there's retaliation, but there's also negative, a negative decision that comes down because of factors that are particular for that case, that they always have had the option to do that. And I think that believing that because you are successful in forcing an adjudication on your case automatically means it's going to be a positive adjudication on your case. People need to know that you can get a preliminary injunction granted and force a decision, and then get a negative decision on your case because there was an issue with the case itself that the government felt like it had the ability to deny the case for legitimate reasons or illegitimate reasons. But they, you can argue that. But I wouldn't assume that, I think a lot of times people think retaliation is a negative decision is retaliation. And that's something that we've talked about before on these live streams, that you need to be, have a very tight, strong case when you win one of these with decisions, because they can still give you a bad decision on the case itself. So keep that in mind.
Right. Somebody said, what's the deadline to get out of the case? Whenever you want to get out of the case. I mean, right now, we just do a notice. If the government files an answer, then we have to get their permission. There is no deadline on that. Explain the additional file. They're talking about 765. What happens next, and what is the expected timeline? We got this decision 6 hours ago. I don't have a timeline for you. I don't think Jesse has a timeline for you. But if we can file a request with the court or the government early next week, because you all work on your declarations, you get them to us, then I suspect it will be relatively quickly after that we get a decision and an order or an agreement. Jess, anything to add on that?
Well, I just totally think that we should try to negotiate with the government attorney first. So we want to get a list from everybody. I think we either asked for that or it's coming. And then we should send an email over to the attorney and just say, hey, should we go through this, or should we work on something for our I think the judge may want to see that and see what they have to say. And so, but if not, then we'll go and proceed with an injunction and see what the judge wants to do about it.
Okay, so let's see. Apparently we suck. That must be me.
For a lot of these questions that are about what are we going to do about this specific thing, that's the type of thing that I want us to talk about on a plaintiff-specific call. There's a lot of questions about what are you going to do, what is the plan for this and that and this. That's one of those things where let's not have it be like, recorded and accessible by anybody. I would want us to have that plaintiff-specific discussion.
Okay. By the way, Jesse is not disrespecting you at all. Jesse respects you a great deal. Don't know how you get that from what he says. Let's see. These are many of the same questions over and over again. Saleh, get us your information, and we'll see if we can get you that EAD as quickly as possible. I don't see any other questions here that are different from what we've talked about already. Now, we are going to have a separate call, just a Zoom call with the plaintiffs. We have to get together and find out when we can do that over the next 48 hours. We'll get the word out to everybody with an email. Everybody should have a copy of the decision in the Georgia case and our email talking about it. And please, those that would like an EAD or you've got a pending H that needs to get approved or a STEM OPT EAD that needs to get approved, please do a declaration so we can get to the government as quickly as we can early next week. Okay. Jess, you have anything else to add here?
No, I mean, I just apologize for the disappointment, and got a lot of work to do, and hopefully change the vibe.
Absolutely. Obviously, I'm sorry that we've lost at this point, but I don't see this as the final loss. I still see us having opportunities here for success for many, if not all, of our plaintiffs. And I don't take the judge's decision in the PI as the final decision in this case. I have won other cases where I lost the PI. We ultimately win the case. So I don't hear the fat lady singing yet. We just got to keep fighting. Anything else, Zach?
Nope. Just if you have questions, comments, concerns, anything like that, IMMPact contact page comes to me. I'm going to get through all of these before I leave the office today. So, please send any questions you have. I will be getting through this.
Yes. And Rosemary, thank you very much. Greg, you have anything else to add before we sign off here?
Nope. I think we covered it, and hopefully we'll be able to get all your questions answered.
All right. We'll get an email out to everybody shortly in the next day or so with a time to do a Zoom meeting, let you ask all your questions individually, and we'll go from there. Until then, let's keep the faith. Let's keep working on this, and we'll go from there. Thank you, everybody.